Disclaimer. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast.
Hi there. So today we're doing a deep dive into something really fundamental for financial and corporate transactions here in Luxembourg, the legal opinion.
That's right. If you're involved with funds, structuring deals, or just general compliance, understanding these is, well, it's pretty essential, isn't it?
Absolutely. It's about knowing what comfort you're actually getting and, just as importantly, what you're not getting. What are the limits?
Exactly. So our mission today, we're calling it a comprehensive analysis of legal opinions in Luxembourg. We want to cover, why they matter so much, who actually has the authority to write them.
The rules they have to follow.
The rules, yeah, and the practical stuff, too. Like, what do they look like? What might they cost?
Yeah.
How long does it all take?
And we should also touch on how things are changing, because the legal landscape here, it never really stands still, does it?
It certainly doesn't. Okay, let's dive right in. Starting point.
Yeah.
Who gets to issue these formal legal opinions? Can any lawyer just, draft one up?
Good question. And the answer in Luxembourg is quite specific. It's a tightly controlled area. The authority to issue formal legal opinions, especially the kind that are regularly provided for payment and relied upon by third parties, that's exclusively reserved for Avocats à la Cour.
Avocats à la Cour. Okay, so that's a particular type of lawyer here.
Precisely. They're lawyers who've gone through specific, pretty rigorous training and are formally admitted to practice before the higher courts. It's not just custom. It's actually written into law, the modified law of August 10th, 1991, on the legal profession.
And I think the Ministry of Justice is quite clear on this point, too.
They are, yeah. If you check the ministry's website, it plainly states, only lawyers may give, on a regular basis and for remuneration, legal consultations. So it really backs up that exclusivity for Avocats à la Cour when it comes to paid formal advice.
Right. So what does it take to become an Avocat à la Cour? It sounds like quite a journey.
It is. It usually starts with a specific law degree.
Yeah.
Then you have to pass the Cours complémentaire en droit luxembourgeois, the CCDL. These are extra courses really focusing in on Luxembourg law itself.
Okay.
Then there's a practical training period, the stage judiciaire, working under a supervising lawyer. After all that, you take an oath and get inscribed on an official list, like List I of the Luxembourg Bar. That's when you get the title, Avocat à la Cour.
That's a lot of steps.
Yeah.
Why such strict exclusivity? What's the thinking behind that? Is it about protecting the public?
Primarily, yes. It's about upholding really high standards and ensuring integrity. Think about it. These opinions are often critical pieces in complex, high-value international transactions. Lots of parties rely on them. So, by limiting issuance to Avocats à la Cour, the system guarantees that the person signing off is a professional who's subject to really strict ethical rules, oversight, and discipline from the Barreau de Luxembourg, the Bar Association. It builds in accountability and reliability.
You mentioned the Barreau. There are two bar associations, Luxembourg and Duchy. What's their role?
Yes, though for the kind of international finance work we often talk about, the Luxembourg City Barreau is the main one. Its governing council, the Conseil de l'Ordre, sets binding internal rules, the Règlement d'Ordre Intérieur, or RIO.
And these RIOs, they cover quite a bit.
Oh, absolutely. They go into detail on professional ethics, conduct, that crucial professional secrecy we'll talk about, fees, even anti-money laundering and counter-terrorist financing obligations. The Barreau handles admissions, supervision, discipline. It's really the gatekeeper for professional standards.
So given this exclusive role for Avocats à la Cour, how do they differ from other legal professionals we might encounter, like in-house counsel?
That's a really important distinction. In-house lawyers give vital advice to their company, of course, but they generally can't issue these formal legal opinions that external parties will rely on in the same way. Plus, their communications might not have the same absolute legal privilege under Luxembourg law as those with an external avocat à la cour.
What about, say, tax advisors or accountants? They often deal with legal adjacent issues.
They provide incredibly valuable specialist advice, and that advice might feed into the background facts for an opinion, but, and this is key, any definitive legal conclusion on Luxembourg law within a formal legal opinion has to come from and be under the responsibility of an avocat à la cour. If your tax advisor isn't also an admitted avocat à la Cour, they simply cannot issue a Luxembourg legal opinion.
So this exclusivity, it's not just a restriction, it's actually a structural feature of the market here. It channels that high-level legal sign-off through a specific regulated group.
Exactly that. It centralizes quality control and accountability. It sets a baseline expectation for anyone receiving a Luxembourg opinion. And yes, it does shape the market, encouraging specialization within law firms, particularly in complex areas like finance. You know the opinion comes from someone meeting these rigorous standards.
Okay, that makes sense.
Yeah.
We understand who can issue them and why it's set up that way. Now, let's talk about the rules they operate under, the ethical framework. What are the core duties for an avocat à la Cour when drafting an opinion?
Right, the ethical compass. This is really important because issuing an opinion isn't just drafting a document, it carries significant professional responsibility. The main rules come from that 1991 law, again, and the detailed RIOs from the Barreau.
What would you say is the most fundamental duty?
I'd have to say independence. Independence. The lawyer must be completely free from any improper influence, whether from the client, authorities, third parties, or even their own personal interests. The law even lists functions that are incompatible with being a lawyer to avoid conflicts.
Why is that so critical for an opinion?
Because the opinion has to be an unbiased, objective legal assessment based purely on the facts and the law. If the lawyer isn't independent, how can you trust their judgment? It would undermine the whole point.
Makes sense. And then they actually need to know what they're talking about.
Absolutely. Competence and diligence, compétence et diligence. They must have the necessary skills and knowledge for the specific matter. That includes language skills if needed. If they don't have expertise in a niche area, they should collaborate with someone who does or potentially decline the mandate.
And diligence.
Diligence means acting carefully, thoroughly, and in a timely manner. The accuracy and the quality of the reasoning in the opinion really hinge on the lawyer being both competent and diligent. And they have an obligation for continuous professional development formation permanent to keep those skills sharp.
Okay. Now, you mentioned professional secrecy earlier. Luxembourg is known for having very strong rules here, right?
Extremely strong. Professional secrecy, secret professional, is a cornerstone. It's described as general, absolute, and unlimited in time. And crucially, it's considered a matter of public order, or public. Breaching it can lead to criminal penalties.
Wow, public order. So it's not just an ethical rule, it's a fundamental legal principle.
Exactly. It's not something the client can just waive easily. It protects the integrity of the legal system and the client's right to confidential advice.
How broad is it? What does it cover?
Incredibly broad. Basically, anything the lawyer learns in their professional capacity. Information confided by the client, of course, but also things they discover themselves, consultations, letters, notes. Even the identity of the client or the fact they consulted the lawyer can be covered in many circumstances.
Why is that level of secrecy seen as so vital? Especially for international clients, maybe.
It's all about trust. It allows the client to be completely open and honest, to disclose everything relevant without fear of it being revealed. Without that full picture, the lawyer can't give proper advice and the opinion might be incomplete or flawed. For international clients dealing with sensitive cross-border issues, knowing their communications are protected by such a strong secrecy regime is a major factor. Though, it's worth adding, this traditional strong secrecy now has to coexist with increasing global transparency demands, especially around anti-money laundering and counter-terrorist financing, AML-CFT.
Right. How does that work?
Lawyers have specific AML-CFT obligations detailed in the RAOs, like reporting suspicious transactions in certain contexts, but their core duty of professional secrecy generally remains paramount. Balancing these duties requires careful judgment. Sometimes opinions are even sought specifically to clarify where those lines fall in a particular situation.
Interesting tension there. Okay, and the last core duty you mentioned.
Managing conflicts of interest, opposition d'intérêt. Lawyers are strictly forbidden from advising clients whose interests clash in the same matter. They also can't act if their own personal interests conflict with their client's best interests.
What happens if a conflict pops up later?
They have a duty to withdraw immediately from representing all affected clients. And importantly, lawyers in the same firm are usually treated as a single entity for conflict purposes. So, a conflict for one lawyer generally disqualifies the entire firm from acting. This rule ensures undivided loyalty and objective advice.
So these four duties, independence, competence, secrecy, avoiding conflicts, They're not just suggestions, they're hard rules baked into the system.
Absolutely. Binding rules. And they all work together, don't they? You need competence to even spot a potential conflict. Independence helps protect secrecy. When an avocat à la cour signs an opinion, they're implicitly stating they've complied with all these duties in relation to that specific piece of work. A failure on one count could potentially invalidate the whole opinion.
Okay, that's a solid foundation. We know who issues them, the rules they follow. Let's get practical now. What does the actual document, the legal opinion, look like? What are its components?
Right, the anatomy of an opinion.
Yeah.
It's a formal document, and it's built very carefully on a specific factual basis, which comes from reviewing documents and doing certain checks.
What kind of documents do they typically need to see?
Well, it varies depending on the transaction, obviously, but you're almost always looking at foundational stuff like the company's constitutional documents, the statutes for an SA or SRL, or the partnership agreement for an SCSP.
Okay.
Then corporate resolutions are keyboard minutes, shareholder or partner meeting minutes that authorize the specific transaction. And of course, the main transaction documents themselves, the loan agreement, security documents, funds prospectus or offering memorandum, whatever the opinion is about.
What about registers and things like that?
Yes, definitely. Shareholder registers, partner registers, beneficial owner registers. For regulated entities like funds or financial sector professionals, PSFs, they'll need proof of regulatory approval, like the CSSF authorization. And a standard part of the process is doing verification searches.
Like checking official records.
Exactly. The Luxembourg Business Register, the LBR, is a key one that's considered a priority one source for official company info. The lawyer has a professional duty, under the RIOs, to request all the info they need to do their job properly.
So the client provides stuff, but the lawyer verifies certain things independently.
That's the idea. They rely on the client and other parties providing complete and accurate information, but they do conduct their own routine checks, like those LBR searches. The exact scope of what they've reviewed and verified is usually spelled out pretty clearly, often in the engagement letter, and definitely in the assumptions section of the opinion itself. Assessing the reliability of all this information takes professional judgment.
Right. So walk us through the typical structure of the opinion document. What sections would we usually find?
Okay. While there isn't one single legally mandated template, especially for international deals, a common structure has definitely emerged. It usually starts by identifying who the opinion is addressed to, the addressee, and the date. That date is crucial. The opinion only speaks as of that specific moment.
Got it. What's next?
Then you'll have a scope and purpose section. This defines exactly what legal questions the opinion is answering and describes the underlying transaction. After that comes the documents examined list, literally listing the key documents the lawyer has reviewed.
And then you mentioned the assumptions section. That sounds important.
Hugely important. Assumptions state the factual and legal premises the lawyer is taking as true without having independently verified them beyond those standard checks we talked about.
Like what sort of things?
Things like the genuineness of signatures on documents they've seen as copies, the accuracy of factual statements made by the client in certificates, or assumptions about aspects of foreign law if the opinion is strictly limited to Luxembourg law. This section is vital for drawing the boundaries of the lawyer's responsibility.
So if you're relying on the opinion, you really need to read those assumptions carefully.
Absolutely paramount. Understanding the assumptions tells you what the opinion is built on. If an assumption turns out to be wrong, it could affect the validity of the conclusions. Alongside assumptions, you have qualifications and limitations. These also limit the scope. Some are general, like stating the opinion only covers Luxembourg law as it stands on the date and doesn't cover commercial or financial advice.
And specific ones.
Yes, you often see specific qualifications relating to, say, the potential impact of insolvency or bankruptcy laws on the enforceability of obligations or limitations based on exactly which documents were or weren't reviewed.
Okay, assumptions and qualifications define the boundaries. Then comes the main event.
Exactly. The operative opinion clauses. This is the core of the document, where the Avocats à la Cour gives their professional judgment on the specific legal points defined in the scope.
What kind of points do they typically cover? For a company, say.
For a standard corporate opinion, you'd typically see clauses confirming the company, like an SA, SRL, or SCSP, is duly incorporated, validly existing, and in good standing under Luxembourg law. Also, that it has the necessary corporate power and authority to enter into the transaction documents and perform its obligations under them.
And that the documents are properly signed.
Yes, that the relevant documents have been duly executed and delivered, and importantly, that the obligations created by those documents are legal, valid, binding, and enforceable against the company, though this enforceability opinion is almost always subject to those qualifications we mentioned, especially regarding insolvency and equitable principles.
What else?
Often, opinions will also state that entering into the transaction doesn't conflict with the company's constitutional documents or with Luxembourg law generally, and that no further consents or approvals are needed under Luxembourg law other than any already obtained or specified in the opinion.
And if it's an opinion for an investment fund?
Then you'll see additional fund-specific clauses. Things confirming the fund's due establishment and proper authorization under the relevant Luxembourg fund regime, whether it's a UCITS, a SIF, a RAI, or another type. And maybe confirming compliance with specific aspects of those fund laws pertinent to the transaction.
Okay. And finally, who gets to rely on it?
Yes, the reliance clause. This normally specifies exactly who is entitled to rely on the opinion. Usually it's limited just to the addressee unless the lawyer expressly agrees in writing that others can rely too.
This whole structure feels very deliberate, very carefully constructed.
It absolutely is. It's designed to give the relying parties specific legal comfort on key points while also carefully managing the opining lawyer's professional liability. Remember, it's a reasoned professional judgment based on defined facts, documents, and law at a snapshot in time. It's not an insurance policy or a guarantee. The assumptions and qualifications are the tools used to define the edges of that judgment.
So reading the fine print, the assumptions and qualifications, is just as vital as reading the main opinion clauses.
Definitely. In many transactions, especially financings, the negotiation between the lender's lawyers and the borrower's opining lawyers often focuses heavily on the precise wording of the scope, the assumptions, and the qualifications. The relying party wants the comfort to be as strong as possible. The opining lawyer needs it to be accurate and legally defensible. That negotiation itself shows how important those boundaries are.
Understood. That detailed structure makes a lot of sense. Okay, let's shift gears to the practicalities. If you actually need an opinion for your deal, how does that process work? What about costs? Timelines?
Good questions. Getting an opinion usually starts with some discussion and negotiation, often quite early in a transaction.
Who's involved in that?
It's primarily between the client needing the opinion and their chosen avocat à la Cour. But especially in deals, the lawyers for the other parties who will rely on the opinion, maybe the bank providing finance or the counterparty in an M&A deal, they'll also be involved. They'll want input on the scope, the assumptions, the qualifications, essentially what comfort they're getting. And of course, the timeline and fees are discussed upfront.
You mentioned the lawyer has a duty regarding fees.
Yes, the RIOs state the lawyer must inform the client about how their fees will be calculated. Transparency is key.
Okay, fees. Is there like an official price list for legal opinions in Luxembourg? A set tariff?
No, absolutely not. There's no legally imposed or official tariff for lawyers' fees here. Avocats à la Cour set their own fees. It's as clear from the 1991 law and guidance you can find on places like guichet.lu, the government portal.
So if there's no set price, what determines the cost?
It depends on several factors, which are actually outlined in the law and Barrow guidance. Things like the importance and the financial value of the matter involved, how complex or difficult the legal questions are, the amount of work and time the lawyer actually spends on it.
Does the outcome matter?
The result obtained can be a factor, but it's explicitly not the only factor. The client's ability to pay can also be considered. And a significant factor is often the experience and reputation, the notoriété of the lawyer and their firm. More experienced specialists in high-demand areas might naturally command higher fees.
How are fees usually structured? Is it always by the hour?
Hourly rates are very common, yes, especially for complex matters where the time needed isn't easy to predict. But you also see fixed or flat fees for more standardized opinions where the scope is clear. Capped fees are another possibility, setting a maximum. Sometimes retainers are used for ongoing work. Success fee components might feature in broader litigation, but pure contingency fees, no win, no fee, are generally prohibited for lawyers here.
So best practice is to agree on the fee structure in writing.
Definitely. A written fee agreement, a convention d'honoraires, is highly recommended and very common. It just avoids any misunderstandings down the line.
And are there other costs besides the lawyer's time?
Yes, you'll usually see separate charges for ancillary costs, or frais. These cover specific out-of-pocket expenses the firm incurs. For your matter, think LBR search fees, courier charges. Sometimes there's also a charge for general overheads, maybe calculated as a percentage of the fee.
And we need to remember VAT.
Correct. Legal services, including opinions, are subject to Luxembourg VAT, which is currently 17%.
Okay, costs covered. What about timelines? If you need an opinion for a deal closing next Friday, can you get one that quickly? How long does it typically take?
Timelines are very much, it depends. There aren't fixed procedural deadlines for issuing transactional opinions like there might be in court proceedings. The time needed can vary hugely.
What influences how long it takes?
Several things. The complexity of the deal and the opinion itself is a big one. How quickly and completely the client provides all the necessary documents and information is crucial. If you need input from lawyers in other countries, that adds coordination time. How many parties need to review and comment on drafts can slow things down. And, realistically, the law firm's current workload plays a part.
Can you give us any kind of ballpark? Days? Weeks?
Well, for a very simple, standard corporate confirmation, assuming all the info is ready, maybe a few business days. But for a complex opinion on a major transaction, a big M&A deal, a large fund launch, a complex financing with security in multiple jurisdictions, you could easily be looking at several weeks, sometimes longer, especially if there's significant negotiation over the assumptions and qualifications.
So the key is planning ahead.
Absolutely. Timelines need to be discussed right at the start and built into the overall transaction schedule. Trying to rush an opinion at the last minute is stressful and risks errors or omissions.
Right. So the big practical takeaways here seem to be talk about scope, cost, and timing early and clearly. And understand that pricing and duration aren't fixed. They reflect the specifics of the job and the lawyer's expertise.
Exactly. Since there's no official tariff, the onus is really on the client to have that conversation about fees up front. And yes, pricing reflects the complexity, the value, the risk, and the lawyer's standing. For clients needing regular opinions, building a relationship can sometimes lead to more predictable or tailored fee structures.
Okay, that covers the who, what, why, how, when, and how much of opinions as they stand now. But you mentioned earlier that the legal world here isn't static. How is the evolving landscape impacting legal opinions?
It's a really dynamic area. Both changes in Luxembourg's own laws and, significantly, new EU regulations are constantly creating new situations where opinions are needed or changing the context for existing ones.
Are there any big domestic reforms affecting the legal profession itself right now?
Yes, there's a major draft law currently working its way through Parlement Projet de Loi 8432. The aim is to modernize various aspects of the legal profession, updating that core 1991 law. It touches on things like recognition of qualifications, potentially rules around how law firms can structure themselves.
And there's been some debate about it.
Yes. Key bodies have weighed in. The Conseil d'État, Council of State, raised some formal objections and concerns about legal certainty on certain points. And the Luxembourg Barreau has also submitted its own detailed opinion on the proposals. So it's still under discussion.
How might a law like that, even if it's about the profession itself, affect the actual opinions firm's issue?
Indirectly, perhaps. If rules change regarding, say, firm structures or professional liability, that could eventually influence how opinions are delivered or maybe lead firms to adjust standard wording around scope or reliance. But that would only be after the law is finalized and everyone's figured out the precise impact. It's not changing opinion content directly right now.
Okay. And what about external drivers like new EU rules or CSSF circulars? How do they impact opinion practice?
They're huge drivers. New regulations, especially complex ones in finance, almost always spark a need for legal interpretation. While the rules themselves might not explicitly say, go get a legal opinion, companies operating under them need expert advice to understand their new obligations, to validate their compliance strategies, or to assess the legal risks of new services or technologies they want to use.
So opinions become risk management tools, in a way.
Very much so. They help companies navigate regulatory complexity with greater confidence.
Can you give some current examples?
Sure. Think about the crypto asset space and the new MiCA regulation from the EU. ALFI, the Fund Industry Association here, has pointed out that legal opinions will likely play a key role in classifying different crypto assets under MiCA's framework.
Okay. What else?
Another big one is DORA, the EU's Digital Operational Resilience Act. It imposes significant requirements on financial entities regarding ICT, risk management, and resilience. The CSSF has been issuing circulars about implementing DORA like 224847 and 25893 on reporting ICT incidents, and 25882 dealing with managing risks from third-party ICT providers.
So companies need opinions on how to comply with DORA.
Exactly. They'll be seeking opinions on whether their internal resilience frameworks meet the standard, whether their contracts with key IT suppliers satisfy DORA's stringent requirements, and how to handle the new incident reporting rules.
And you mentioned contracts. New regulations often mean updating documents, right? Opinions would check those updates.
Precisely. New rules frequently require changes to existing contracts, service agreements, or internal policies. Companies will get legal opinions to confirm that their amended documents are legally sound and actually achieve compliance with the new requirements. DORA's rules on ICT provider contracts are a prime example. Firms are amending those agreements now and will want opinions validating those changes.
So it sounds like new laws and regulations are constantly feeding the need for legal opinions, pushing them into new, complex areas.
That's exactly right. The demand is often event-driven by regulatory change. Opinions are crucial tools for managing the risks and uncertainties that come with that change. And the increasing complexity, especially in finance, tech, and areas like AML, means we're seeing more demand for highly specialized regulatory opinions going beyond traditional corporate law. This definitely encourages Avocats à la Cour to develop deep, niche expertise.
That was a really thorough exploration, a proper deep dive. Let's try and crystallize the main takeaways for everyone listening.
Okay. First off, the power to issue formal Luxembourg legal opinions rests exclusively with Avocats à la Cour, that's law, governed by the 1991 Act and overseen by the Barreau.
And these lawyers operate under strict professional duties. Independence, competence, diligence, avoiding conflicts, and that incredibly strong professional secrecy, which is public order here. These duties are vital for trust.
Then, the opinion document itself. It's carefully structured, based on specific documents reviewed, stated assumptions, and qualifications. It offers a reasoned legal judgment at a point in time, not a guarantee. Reading the assumptions and qualifications is crucial.
Practically speaking, remember, costs and timelines vary. There's no official price list. So discuss fees and the expected time frame up front with your lawyer. It depends on the complexity and the lawyer's expertise.
And finally, keep in mind the landscape is always evolving. Domestic reforms like the draft law 8 432, and especially new EU regulations like DORA and MICA, constantly create new challenges and drive the need for specialized legal opinions to navigate compliance and risk.
Excellent summary. Before we sign off, just the important reminder again.
Disclaimer. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice.
Thanks so much for joining us for this deep dive on Luxembourg legal opinions. We really hope it's giving you some valuable insights. If you found it useful, please do hit that like and subscribe button. It was the Luxembourg Fundcast for you today.